The civil procedure question from July of 2000 is one of my favorite bar exam essay questions ever. It's certainly my favorite civil procedure fact pattern. And the reason is we get to evaluate the decisions of 3 different courts, and all 3 get their questions wrong. So we're going to express some hostility for the judiciary in our answer to this fact pattern. I think it was clearly written by a plaintiff's lawyer who is frustrated with his experiences with various bench officers. Take a look at the 3-part call of the question. 1. Was the federal court correct in dismissing the action on the grounds of impossibility of proper joinder of Amcorp? Discuss. A fairly technical question, but as it turns out, we will have a fairly simple answer. The answer is no. Move on to call 2. Was the state court in State B correct in dismissing Amcorp from the action on the ground that it lacked personal jurisdiction over Amcorp? Discuss. Well, we call up our various checklists on jurisdiction, and we wait to read the facts. Then, call of the question 3, was the state court in State A correct in dismissing BigCorp from the State A action on the grounds of res judicata? Discuss. Well, we have to look to see if parties or privies had been involved in prior actions and see if we agree with the state court. So it's a pretty straightforward 3-part call of the question, although we are being asked to second-guess 3 different courts, federal court and then state courts in states B and A. Please go to the top of the question and let's review the fact pattern quickly. We only have 3 paragraphs of facts. That gives rise to our presumption that this will be a tricky, hard question. Actually, it isn't so hard. Take a look at paragraph 1. We meet BigCorp. They are incorporated and headquartered in State B. While in State B, Paul, a citizen of State A, is severely injured by a defective power saw at a store owned by BigCorp in State B. There's a products liability action for $10,000 against BigCorp in federal district court in State B based on diversity of citizenship. Okay, well, let's stop right there. Any jurisdictional problems with this case so far? None apparently. So read on. As discovery progressed, BigCorp disclosed that although it manufactures its own power saws, the particular saw allegedly injuring Paul had been manufactured in State A by Amcorp, which is incorporated and headquartered in State A. Amcorp and BigCorp generally conduct business solely in their respective states, but sell surplus goods to one another twice a year. All right, that's interesting. Now we know that there is a possible second defendant out there. If the plaintiff tries to bring that defendant in, he should be barred from doing so because it would destroy diversity. But we know that the supplemental jurisdiction of the court would allow Amcorp to be brought in for an indemnity claim brought by BigCorp. Well, let's read on. In paragraph 2, the plaintiff makes his big mistake. The plaintiff seeks leave to amend his federal court complaint to name Amcorp as a defendant. BigCorp opposed the motion, correctly, claiming that such a joinder would defeat diversity, and moved for dismissal of the action, the whole action, because of the impossibility of the proper joinder of Amcorp. Well, here's an example of a defense counsel asking for a lot more than he or she is entitled to. The defense would be entitled to have a denial of the motion to amend the complaint because it would destroy diversity. But to ask for the whole complaint to be dismissed is overstepping the bounds of what the law should allow. However, the federal court is very pro-defense. They dismiss Paul's complaint. Then Paul refiles his action against both defendants in state court in State B. Amcorp files a motion to quash, contesting personal jurisdiction, and the State B court determined that it lacked personal jurisdiction over Amcorp and dismissed it from the action. Well, that's another court that has made a mistake. We move now to paragraph 3. Paul voluntarily dismissed his action against BigCorp without prejudice. Paul then brought his products case in state court in State A, naming both defendants again. Now BigCorp moves for dismissal of BigCorp on the grounds of res judicata, and State A has a judge that grants the motion. What law school did this bench officer go to? This is a claim that never has been litigated, so clearly res judicata can't apply. So we've got a short fact pattern, and it turns out to be a simple one. We've got to be able to think clearly, and we have to be prepared to criticize every court that makes a decision. But once we actually get into organizing our answer, we see just what a big favor the Committee of Bar Examiners has done. This is a simple problem, and it's easy to write a very solid, persuasive answer within time constraints. So look at our outline of issues, and with regard to the first call of the question, you'll see that perhaps this is where the most complicated analysis lies. We focus first on the underlying diversity jurisdiction. We talk about diversity of parties and the amount in controversy. Next, we focus on the plaintiff's efforts to join AmCorp. We talk briefly about what joinder is, but certainly it wouldn't be possible for the plaintiff to join this defendant because it would destroy diversity. And the plaintiff is not allowed to amend his complaint to add a defendant that would destroy diversity. There has to be complete diversity between the plaintiff and all the defendants the plaintiff sues. So I have a section next in line about supplemental jurisdiction. If there was really a problem between Big Corp and AmCorp with regard to the allocation of the plaintiff's losses, that's an indemnification claim. We don't need to have the plaintiff filing that action. One defendant can bring in another defendant to litigate an indemnity claim, and supplemental jurisdiction gives the federal court the authority to do that. So ultimately, I conclude that the federal court erred in dismissing the whole action. Next, we turn to the state B court's dismissal of AmCorp because of personal jurisdiction. Here, we're doing an analysis that we can pretty much do in our sleep at this point because we've seen this issue tested over and over again in exactly the same way. How many different times can they test minimum contacts? Answer, as many times as they want. So here I do the same thing I always do for minimum contacts, the same thing that everybody is supposed to do for that issue: purposeful availment, foreseeability, fairness. The simple, quick, and correct bottom line is the state B court got it wrong also. Finally, we turn to the res judicata issue, and here the outline of issues is simple. We've got a former party or privy. The claim was never fully litigated. Therefore, the state A court got it wrong also. Res judicata will not bar litigation of this claim. So, with all of that said, and can a very solid answer easily be presented? Answer, yes. With a question this simple and direct, we need to find a home for all of the facts, and we should not be leaving out issues. One little sidebar that I can't resist here. I think that this is a fair example of a question from the bar examiners that has correct answers. I think if you get any one of these conclusions wrong, you're in a little bit of trouble. And if you get a couple of them wrong, you're probably not going to get a passing score. This is a fact pattern that does have correct answers. And if you get them wrong, then maybe you should be on the bench in these various jurisdictions. Still, for bar exam purposes, it's best to get them right. So let's go into the analysis, and I'll point out a couple of highlights. Look at the very first paragraph in the answer. Here, I lead with the facts. I do it all in one sentence. Next, we focus on the core issues, diversity. I lead with the law and a couple of facts setting up diversity. Then I focus on the elements, the diversity of parties and the amount in controversy. Both of these are satisfied. And so, then, I turn to the plaintiff's effort to bring AmCorp into the action. I lead with the facts again internally, directly under Part B, indicating that Paul has discovered this new defendant exists in discovery. Then I focus on joinder, and this section is probably the most complicated, and it's also probably the one that you're likely to learn the most from. Look at the paragraphs under joinder, and in particular with regard to the fact that AmCorp is neither necessary nor indispensable. This plaintiff can get full relief without having to personally sue this defendant. Therefore, we then focus on supplemental jurisdiction. I've already explained that as much as I need to in this brief commentary. I think the paragraph restates the bottom line effectively and concisely. So I conclude that the federal court got it wrong. They should not have dismissed the whole action. It should have denied Paul's motion and then left it to the defendant to decide whether or not it wished to pursue an indemnity claim against AmCorp. Next, we we focus on the State B Court's dismissal of Amcorp because of personal jurisdiction. Here again, I lead with the facts. I explain what happened, and I set up the analysis in a clear, concise, and factually specific manner. So, next, we turn to minimum contacts. Here, I actually lead with a brief statement of law, and then I focus on the elements. Purposeful availment certainly does have plenty of facts that we can use to establish the fact that this defendant, Amcorp, has plenty of contacts with State B. Next, I focus on foreseeability. And really, let's pay attention to the subject matter of this lawsuit. We are dealing with a products liability case involving power saws. These products are associated with serious accidents everywhere they are sold. So it's foreseeable that a customer in State B would get hurt and would want to seek remedies in State B. Finally, I focus on fairness, and here again, I focus on the facts, but I analyze them in light of the law and the policies that underlie the law. So, I conclude correctly that the state court was wrong in dismissing Amcorp from Paul's State B action. Finally, I turn to the State A court's dismissal of BigCorp, and notice how here even my introduction indicates that I appreciate the fact that this plaintiff has been having a pretty bad go of it in the judicial system. He's already been the victim of two clearly errant decisions on the part of two different judges. So now he faces his third court, and again the court gets it wrong. So we focus briefly on the elements, that we've got a former party in privy involved. BigCorp has been a defendant before, but the problem is the claim has never been fully litigated. And I indicate why that is. The first action was dismissed by the federal court for jurisdiction. Paul voluntarily dismissed the State B action without prejudice before there was any finding on the merits. So the bottom line here is the State A court incorrectly dismissed BigCorp from Paul's State A action. And that wraps up an analysis of a very straightforward, simple, and, I think, easy civil procedure fact pattern. There are a couple of complicated issues. Have a look. I think you'll find them instructive.